You are listening to Lone Star Community Radio on 104.5 KCZWLP Conroe and 106.1 KZCCLP Conroe and worldwide on irlonestar.com.
Good afternoon and welcome to the Legal Connection Show with Toni and Cheryl. This is legal advice from Montgomery County's lawyers, two of Montgomery County's lawyers, Toni Sheritz Collins and Cheryl Ellsworth Jahani. And we're here this afternoon to give you a little TLC, and we're going to be talking about appeals. So Toni, let's get started. Let's start talking about appeals today.
Okay, and I'm going to correct you. It's Toni L. Collins. The L stands, so I have TLC, and the L stands for late. I'm late for everything.
All right, I know that that's true.
and going there, before we start with the appeals, I have a little joke.
All right.
Okay. A little girl dressed in her Sunday best was running as fast as she could, trying not to be late for Bible class. As she ran, she prayed, "Dear Lord, please don't let me be late. Dear Lord, please don't let me be late." As she was running and praying, she tripped on a curb and fell, getting her clothes dirty and tearing her dress. This has happened to me before. Not necessarily going to Bible class, but it's happened. She got up, brushed herself off, and started running again. And as she ran, once again, she began to pray, "Dear Lord, please don't let me be late, and please don't shove me either." I always need a little shove, which kind of goes, and God is helping me with regard to that. And that kind of goes toward what we're going to talk about today, appeals. Because sometimes you need a little shove. You know,
right.
It's scary, the legal, just being with anything that has to do with court and the law. It's scary if you don't have, even when you have representation, it's pretty scary. And, we shouldn't be afraid. We shouldn't have fear. We should trust that everything's going to be okay. Because you can appeal.
Absolutely. I know that this topic has been on your heart for a long time. Why appeals?
In part, and as you know, we both went to South Texas. Mm-hmm. South Texas, they are like number 4 or 5 in the nation in moot court, right. Of all law schools. Mm-hmm. It's a very, very reputable school.
And moot court is mock court. It's where they go around the country and compete with other teams from other law schools.
Mock trial is when you're doing actual trial advocacy, like you're in the courtroom. Mm-hmm. Moot court is the advocacy with regard to appeals. Right. And you've got an appellate brief, and there's all these procedures. But so I believe South Texas does really well with mock trial.
They do.
But they exceed, and they beat almost every law school in the country when it comes to moot court, which is appeals. And as you know, the appeal, just as far as the definition, an appeal is a request for a higher court to review a lower court's decision. And it doesn't happen. Actually, appeals aren't just with court. You could appeal anything in life, But with regard to court, there are different types of appeals. I guess what comes to mind immediately is appealing to your parents. If you've got 2 siblings that are arguing with each other, one may be a little bit more, I guess, worldly or wily is the term I'm looking for than the other, just by nature, and they may be able to manipulate the parent a little bit better,
right,
because, and the other one just doesn't know. You've got sort of a Beaver Cleaver and Eddie Haskell thing going on, and so anyway, we're going to help sort of direct our listeners to how they can get fairness and justice. And today you probably noticed that I didn't bring my little baby 10 Commandments I got from the Bible Museum.
I did notice that.
I forgot. I almost went back to get it. And I just want to say one thing about that. I forgot it, but that doesn't mean that it's not really important, because the Bible is actually sort of the basis for our law. I feel pretty strongly about that. And there's a lot of different, there are a lot of studies on that. University of Houston had one recently within the last few years where they were comparing the commandments to the actual law. Mm-hmm. And it was only 5 out of 10 which were actually, commandments that had a law that went with it. Like,
well, that's huge.
It's still huge,
Yeah.
but I believe that, and it's not just me believes this. There's been so many studies that this nation was built on the law, basically, on the Bible. And I'm just going to give one example, and then we're going to go on to what we really need to tell our listeners about.
All right.
And that is the principle of our nation, the sovereignty, authority of God, the sovereign authority of God, not the sovereignty of the state or the sovereignty of man, is what we should live our life based on. And the legal documents that support that are all over the place. We just got back from Washington, D.C. The Mayflower Compact, the Declaration of Independence, the Constitution. Our currency says, "In God we trust." Oaths, we swear on the Bible. The mention of God in all 50 states' constitutions. And the Pledge of Allegiance. So very important. And there's, I don't even have to go into the biblical references because there's just so
Right.
many. But that leads me to football.
Okay. Well, with the Super Bowl just
Yes.
a few days ago, yes.
And so my question for you is, who did you want to win?
Oh, Tom Brady and the Patriots.
And why?
Well, I know it's, boring and all of that, but I felt like he deserved it. I felt like that, he would have been the greatest winning quarterback of all time. I feel like that guy is incredibly talented, and, they weren't the underdog, but I was rooting for him anyway, and so that's who I wanted to win.
Well, I like the name Patriot.
Mhm.
And I love that he's a devout Catholic, and I love Giselle, his wife. And I don't like that he dumped his first girlfriend 6 months pregnant. That didn't sit well with me. But then, the King David did sort of, the same thing, and God still forgave him. But I thought that Tom Brady he's won enough. I mean, he's got a lot of victory.
See, everyone said that.
And he's had so much, good things going in his life, and then Deflategate and all that stuff.
Right.
But then I really wanted to win because he was so devout, and I really liked him, and he wanted to be on the Catholic channel and all that stuff. I just really liked it. But then I started reading about Nick Foles. Oh my gosh!
Right. Awesome
When
guy.
he is from Austin,
I did not know that.
and he beat Drew Brees, who's also went to Austin in high school.
Awesome.
And he
guy.
beat a lot of his records, and he's studying online to get a master's in divinity. He's very devout, and he had the cutest little baby,
I
and
know.
he played so
And
well.
holding that little baby at the end, wasn't that adorable?
And he's
Sweet.
only 3 months older than my oldest stepchild, and when I saw he played so well, and when I saw that he was also, everything he was doing, and his whole team was like really giving the glory to God
They
for their
were.
win.
Even the
like,
coach, the head coach, thanked Jesus Christ.
Yes,
Right.
Yes, I thought, okay, I was so glad that he won. And then I was like, okay, Philadelphia Eagles, I was really happy they won. So that kind of went, I brought that up because it was NFL and debate night and all that stuff.
And relevant. Well, what about a historically interesting fact, George Washington's appeal to heaven? I think that's relevant.
Yes, and then we're going to get on right into what our readers, our listeners really need to learn about.
Just quickly, I think that our listeners don't know that the colors, the white flag with the green pine tree and the inscription "Appeal to Heaven" was actually commissioned by George Washington, originally in 1775. Colonel Reed, who was Washington's secretary, suggested the motto, and it's used today in Massachusetts?
Oh, in Massachusetts, but it's actually a flag that's still used. But George Washington flew this flag that says "Appeal to Heaven," and I'll show you a picture of it. It's so basic. I don't know if for our podcast people what it looks like, but
Just a white background with a pine tree.
Yes, but it had so much significance because our forefathers, 95% of them were Christian, and of course they based most of our original law was based on the Bible and those precepts. But more importantly, they felt that there was an injustice, and so they made this flag, and it flew on George Washington. Every ship in the U.S. Navy, and of course the Navy wasn't that big at the time because we were just a developing country, flew this flag, and it was actually the first. I think it was not the United States, but the first colony's flag was this flag that was developed by the Secretary George Washington. And what he said was, "And where the body of the people or any single man is deprived of their rights, or is under the exercise of a power without right, and have no appeal on earth, they have liberty to appeal to heaven.
That's right.
Basically, they felt like they had nowhere to turn. And so our forefathers appealed to heaven, and that's why they made this flag. And I just thought it was so interesting because I never knew anything about this flag, and it kind of came up when I was Googling some stuff. And it kind of goes toward what we're talking about today, appeals.
Right. Appeal. So, Toni, why would someone appeal? Why? Obviously, you're going to appeal a decision that you got in a trial court or a lower court. That's what we call trial courts. Those are our lower courts. And something went wrong. Something happened that you feel was unjust, unfair. And so, a lot of times people appeal not because somebody got paid off, like you said, not because you had a terrible lawyer, but because the court didn't get it right.
Well, yeah, and sometimes they don't, and it's not necessarily the judge, if you had a bench trial, or the jury. Sometimes they haven't not been given the proper information to make the decision. And, just like in the Book of Wisdom, God has had some hand in whether or not, and the judges that actually, you have to respect them. Right. Because they would not be judges but for God's hand. Mm-hmm. Even if it's not what you wanted, for some reason they are, and you've got to totally respect their decision. And we have amazing judges here in Montgomery County. In fact,
yes, we do.
We have amazing judges in Harris County. I just got back from court on Friday, and I just knew that the facts in my case were so bad. My client was, my facts were bad. I was going to have to accept whatever I could get, basically with a negotiation with the prosecutors in this criminal case, because my facts were not going to come out with a dismissal or him off of whatever this was. And he accepted that too. I mean, I've got really good clients for the most part. They're very honest with me, and he accepted the inevitable. There was going to be a punishment for what he did. But when I approached the judge, I was so relieved to see that not only did he have a heart, not a mechanical pump, but he was very fair, and he gave them everything that I had asked for, pretty much without actually asking for it, but just hoping. The judge gave me, and I was just like, oh my gosh, this was, an appeal to heaven, basically, because we prayed a lot about it. And my client got a really, really good, he got a really good recommendation from the judge. He was happy with it. I was happy with it. So that was a win-win situation. It's not always like that, though. Mm-hmm. And we're going to discuss, I guess, after our next break, what the criteria is for you to have an appeal.
All right. So we'll be right back after the break. You're listening to the Legal Connection Show with Toni and Cheryl. Check us out on legalconnectionshow.com and send us your questions at legalconnectionshow.com/contact. We'll be right back.
Don't forget to download the Lone Star Community Radio app for your Google Play or Apple Store. Bring Montgomery County's community radio with you anywhere with your smartphone or tablet. If you are in the Conroe area, tune in on FM. That is Conroe's FM 104.5, 106.1.
Relax with a cup of joe or your favorite drink for the Conroe Lake Conroe Chamber of Commerce Chamber Chat. The show airs on the first Tuesday of the month at 11 a.m. on Lone Star Community Radio. Join hosts Courtney Galley and Brian Bondi as they chat about the Chamber's events and programs for the month and invite Chamber members into the studio to talk about their upcoming events and businesses. Learn about your Chamber with Chamber Chat every first Tuesday at 11 a.m.
Welcome back to the Legal Connection with Toni and Cheryl. This afternoon we're talking about appeals. We've talked about sort of a broad overview of appeals, and now we're going to get into what makes a good appeal. Toni, why don't you tell us, again, we want to do the definition of appeals or inform our audience about the definition. An appeal is a request for a higher court to review a lower court's decision. An appeal lawyer handles an appeal when a party loses or is unhappy with some part of the judgment, and appeal court reviews the record made in a trial court. That's an appeal. So what makes a good appeal?
And depending on what side of the fence you're on when you go into this appeal, I guess that's there would be different answers to that. But the legal answer, at least in Texas, it can be found in the Texas Rules of Civil Procedure and Texas Rules of Appellate Procedure. And, just like with anything else, you have to sort of use your judgment. You have to do the right thing. Not every case is appealable. You may be very happy with the result, but it may be a fair result, and you have to look at what the jury heard and understand that our citizens that actually go to jury duty, and they're out of a day when they would rather be watching, Kelly and whatever her new host name is, Ryan, they'd rather be doing anything else than going to do their civic duty.
Right.
But they show up. And
yes, absolutely.
my experience with trials has been most juries have always put forth, every effort to do the right thing. Very seldom is the jury tainted, but sometimes it is. Sometimes there's a bias. Mm-hmm. Sometimes you have not done your voir dire right, and you've got somebody that had a bias, and you don't. And when people have a bias, they will automatically make a decision that's not based on the facts,
right.
And that's what you have to sort of guard against. And so if you were not happy with the decision in court, and as a matter of law, you know that the decision was wrong. You don't know why. Maybe the judge was just wrong, or the judge didn't know the law. It was a bench trial. Maybe there was a bias with the judge for whatever reason.
Right.
Maybe you didn't make the proper campaign contributions, or you don't know. We don't know why, but we know that something was wrong and somebody else has to look at it. Then you have to go forward. But to do that, you have to have the proper elements and criteria to go forward, to have a legitimate appeal where you can win. You just don't want to like loosely go about it because you could be sanctioned.
Right.
And you've wasted a lot of time. And being in lawsuits, as anybody that has been in one knows, is taking away the joy of your life. We should be, so happy that you're alive and breathing. Instead, you're tense and weighed down. And this is just as bad for the attorneys as it is for the client, because
mm-hmm.
your client is calling you all the time.
Mm-hmm.
The money is not the issue. It's the joy of life. And
right.
you've wasted a lot of life and you don't want to go forward with this. You just want to accept it and move on if that's the way it's going to be. Okay. But that being said, an appeal is a post-judgment procedure. And the very first place I always go is for, I don't want to get into too much technicality because we could talk about appeals for 2 days.
It's complex law, isn't it?
But just in general, so we can just hit the highlights for people that really don't know that much about it. The first thing I look at is to file a motion for new trial, or what your basis would be for a new trial. Mm-hmm. And I'm going to let you talk a little bit about the different courts and what the time frames are for that. But as far as motion for new trial, you want to go to the Texas Rules of Civil Procedure 320 through 329, and anybody can just Google that, and you can see what the there's like 5 points in that. Now, time frames are important, and if you file a motion for a new trial, it's going to move up the time frame for when you actually have to file an appellate brief and various other technicalities that you have to have.
Right.
But you can also file other post-trial motions that move the time that you have to file a brief forward. And I'm talking about in county court and in district court, because there's so many different courts and different types of appeals and procedures apply in the different courts. But in general, if you just want to kind of have something, a basis in general, if you can go to just the standard law is the first thing you look at as a grounds for a new trial under the Rules of Civil Procedure 320 was there jury misconduct. I think we've all watched, or I hope many of us have seen this, the classic 12 Angry Men.
Oh, yeah, right.
Okay.
Henry Fonda.
Yeah. And in your opinion, do you think there was jury misconduct in 12 Angry Men?
Well, according to the rules, absolutely there was, because jury misconduct is a juror bringing something outside into the deliberations of the jury. And I remember that movie with the knife, and he walked around the streets and all of that, and he brought the exact knife. You could pick it up on a street. And the prosecution in that case against a young man made it look like this special knife with special carvings and all of that, and Henry Fonda found 100 of them with one vendor. And so, according to our definitions, there was definitely jury misconduct in that. What a great movie, though. You know, and the whole time I was in law school listening to this jury misconduct, I was thinking about that movie and how these rules aren't fair.
Yes. And then we've got other movies, and I can't think of them right off because I haven't written them down, but where, and I'm thinking right off with Law and Order, which I love Law and Order.
You know, I have never watched that.
What?
No, but I
gosh.
love The Good Wife, and that's a jury. That's illegal.
I've never watched that.
That's a good one, Tony. You need to watch
girl
it.
thing.
Yeah.
I think it's because I do so much criminal defense that Law and Order, I watch it. The one thing that's really not, it's just not real, is that they have the defendant, or the perp, as they say, in a little cage in the district attorney's office. You know, and they're like, it's like, I've never seen that. Not even in a small town have I ever seen that. So that's kind of far-fetched. But I do like some of the angles that they take. I mean, and I kind of watch that, just like my husband watches medical shows. He's letting me know when those aren't really real, and he's rolling his eyes all the time. And I can't remember. I think we've watched Scrubs a few times and some other ones. But anyway,
But as far as the law of appeals, I think for our listeners, it's interesting. They would be interesting to them is we have the trial courts, and that's where all the drama goes on, most of it on television and all of that. But then every other court is an appellate court. Even the Supreme Court of the United States is an appellate court, and I think that's where people get confused. In the appellate courts, they don't go into the weeds of the facts. They just look at procedural things, and this is what you're talking about how to, or you were talking about a few minutes ago, how to set up a trial case for appeal. You need a good attorney to do that. Are you really, like you, or you need to know what you're doing as an individual.
Now, let me correct you on one thing.
Okay.
On the appellate court, the facts that were presented and admitted into the court are, that is your appellate case. That it's critical, and that you get your facts in. And that's why sometimes cases are lost improperly, because the facts could not be admitted to the jury for the jury to make a proper decision based on the facts that existed. So the facts are very important. Now, procedures are, if you don't follow the procedures in an appeal, you will lose the appeal. You will lose your appeal on just because that you've got to be so precise in the way you follow them. And I will say this, our appellate courts here in Texas, I have not had any bad experience with them. And I'm not just saying that because they'll ever hear this. They may never hear this.
Right.
They follow the rules. If you call an appellate court, if you just call the clerk, they will help you. They won't help you with the law because they can't
Give legal
advice.
Right.
But they're the most helpful, nice people ever. But attorneys are not attorneys.
That's great.
And but that being said, let me go just to correct you on the facts. The facts are the most important thing in appellate law. The facts that the appellate attorney sees, the group, because I had interned for the First Court of Appeals for at least for one summer, and I got to see kind of the inner workings of that particular group, which was amazing to see how they actually go through it. And it was there's lots of different attorneys within the appellate courts that are looking there. It's a fail-safe. Everyone's looking at it over and over again. It's not just one person looking at it.
Oh, that's
but
great.
That being said, I'm going to backtrack a little bit to the 5 things that you have for an appeal.
Okay.
Jury misconduct, and I kind of got sidetracked on that. You redirected me. Is really important because there can be jury misconduct. Because if someone doesn't tell you during the voir dire that they are a voir dire, or whatever they say, I don't know what they say in Texas.
Voir dire.
If they don't tell you that they were, they've got a bias toward, all Catholic women who have brown hair, and then you find out, and that's what your client is, or that's what you are, because they're also looking at you, then that's jury misconduct. They've lied to you, and they shouldn't have been on that jury. So that's the first reason that you can get a new trial and perhaps get with a new trial. You wouldn't even have to go to appeal. It'll get dumped right back to the court because the trial judge decides that. The next thing is an inadequate record, and a new trial should be granted in order to preserve the right to appeal when a party exercises due diligence but is unable, through no fault of their own, to obtain a proper record of the evidence introduced at trial. That can happen for so many reasons. If for an example, if the opposing counsel objects to something that should come in, or if you've got an expert that they should come in there and let the jury help for
Yeah.
the jury's benefit here, and the judge doesn't let them in, that is an inadequate record. Or that is an argument for an inadequate record. Not
Right.
necessarily, because you don't know what, there's an argument for both sides. But an inadequate is another reason for a new trial. Newly discovered evidence, because the other side didn't give you evidence. In civil, it gets you a new trial, but in criminal, it's an absolute reversal if the prosecutors withheld evidence improperly. We've seen that on TV so many times.
Right.
All right. Factual sufficiency, legal sufficiency are the other two that get you a new trial. And we will go into a little bit more about the necessity of motions and the different courts and the time frames in our next segment.
All right. So again, you're listening to The Legal Connection with Toni and Cheryl. You can check out our website at legalconnectionshow.com, and you can email us your questions at legalconnectionshow.com.
Our talk shows and music shows are looking for sponsors. Want to expand your brand awareness? Reach the hyper-local audience in Montgomery County? Lone Star Community Radio sponsorships accomplish this. Want to see our stats and rates? Check out irlonestar.com/sponsor for more information. Or call in and leave us a message at 936-647-3776.
Hey guys, this is Connor.
This is Dick.
This is Chris.
And we're with the Ticket Stub Podcast every Thursday live at noon on 104.5 and 106.1 FM in the Conroe area. Also, anytime at irlonestar.com. You go to irlonestar.com/TTS. You can find all of our social media.
And don't forget, we give away 2 tickets to the Grand Theater on every show.
If you like movies and you like complaining or celebrating anything that has to do with the silver screen, check out the Ticket Stub Podcast and join us every Thursday at noon o'clock on Lone Star Community Radio.
Welcome back to the Legal Connection Show with Toni and Cheryl. We are here talking about appeals today, and Toni's just been telling us about the reasons that we can appeal a trial court decision that didn't go the way we felt like it should have. I think one of the important things that I'm Cheryl, and one of the most daunting and important things about appeals is that they have some pretty strict time limits. In the municipal or city court, you have to request the court record at the trial. The court has to enter the final judgment, which can be extended for certain reasons. You've got to file a written motion for a new trial not later than 10 days after the final
Now,
judgment
let
is
me
entered.
ask you this. With the city, I'm not familiar with any city that actually holds court. But they have ordinances, and I think that would have to do with permitting.
Absolutely.
And any sort of rules that on a local level, a local ordinance, that they've ruled against you on with regard to.
Or fined you
The
for
first thing that
something.
comes to mind is permits and, anything by the commissioner, any of our local officials. If you feel you were wronged, then there is a process by which you can request that they review it again. And that is your type of appeal, and this is what you're speaking of, right?
That's exactly right, Toni. Thank you for clarifying that. And then there are some things that are required of you to appeal that decision. Then it'll go up. You've got to file a brief, and it'll go up to an appellate court to determine whether or not your request should be granted. And then also,
But no, that wouldn't be on the city level, though. I don't think I guess you could file a brief, actually.
yeah,
You want documentation because, with time, people forget things, and the written word, just like in the Bible, is going to be so much more important than the oral. But yeah, I think you're right. A filing a brief would probably be helpful.
right, and when we file a brief, what is that? That's really telling the appellate court what happened and why we think it's wrong.
Or whoever the appellate authority is, right? Whether it be a commission or the city hall or an appellate judge or whoever it may be. And it could be like in your own family, your like when you're a kid, when you wrote little Post-it notes where you're going to appeal to your parents for a larger allowance or whatever it may be, assuming that you were,
Right.
That's how kind of I was. I was always, I was always prepared when arguing before the higher authority, which was my parents.
Absolutely, or why you shouldn't have to wash the dishes tonight.
Yes, and here's the list on why somebody else should and not me.
That's absolutely right. And then we go into the federal, civil, and criminal appellate courts. And there's a procedure for that, and it's all in our Texas Rules of Civil Procedure. and can be found there. But roughly, it's you ask the judge to overturn the jury's verdict or the verdict that you got at the trial court level and enter a not guilty verdict, and you need to do that immediately. And then you can move for a new trial, ask for a new trial, or ask the judge to declare a mistrial for some reason.
Well, I think you would ask for a mistrial if it was during the actual trial itself, because something would happen where the jury couldn't make a right decision because something that was influenced, like somebody screams something that's derogatory, or something that wasn't supposed to come in. That'll be a mistrial, and there's a number of reasons how that can occur. But if you've gotten a bad ruling, generally in county or district court, you've got 30 days. Generally, I mean this, and I'm going to say that's in Texas for sure.
No, that's true. 30 days.
You've got 30 days from the date of when the order is actually signed to do several things. You file a motion for new trial, if that's what you choose to do. That extends your deadline for actually filing an appeal, the notice of appeal. But we have to do it within 30 days. It's really important that you do something within that time frame, whether it's file a notice of appeal, or file a motion for new trial, or file a motion for reconsideration, or file a motion notwithstanding the verdict. Something's got to happen within a certain time frame, and there's a lot of different options. And so you have to decide what option is going to be. But timing is everything on an appeal. And you may have been getting ready to cover this. I think in municipal, it's like 10 days from whenever it happens, and it's an oral rendition of whatever a permit was. But you've got to move really fast. You can't just sit on it. And a good example, I think, for a lot of our listeners is in family court. And this may be known by a lot of people, and I'll tell you what, there's a lot of, not only jailhouse lawyers, but people that have been in court more than you and I have, and they're not lawyers. They're just in court all the time because they go to the court, for their family issues. Maybe they're like my second husband, who was married, a gazillion times. And so they know, but he was a lawyer too. But people are in court a lot for that reason, and they learn to do it on their own. In family court, though, if you have the associate judge make the decision for temporary orders, and it's generally going to be for temporary orders, and you don't agree with those decisions, for whatever reason, it's a full-blown trial, it's a hearing, transcript, everybody's sworn in, witnesses, and you don't agree with it, you have 3 days to appeal and get the whole thing to be a redo with the actual presiding judge in the state of Texas for that family court. And it's a lot of work.
3 days.
3 days, and you have to file basically it's a notice of appeal, and you can look for the procedures and the Texas rules of procedure. But I've done this before, and you can file a petition for a de novo hearing and have a whole redo all over again. And you don't even have to have, I think you might have to have a legitimate reason. The rules are in there, but if you are not going to go through this unless you thought there was a legitimate reason that you needed.
Right.
Otherwise, you're going to negotiate. It's so expensive and so time-consuming and so awful. Right. Another thing is for subpoenas. It's sort of like an appeal, but it's really not. If the opposing counsel notices you to show up for a deposition, and I meant subpoena, but I meant deposition, because you can have for a deposition, it can be with a ducis tecum, and so they're asking you to bring documents. But if you simply file a motion to quash with no reason given within 3 days and timely file it, you're not required by that court order to appear. You file the notice. And so that's another form of an appeal.
It's a procedural.
But it's a timing thing.
Absolutely.
It's critical that you don't just sit on it. You better look up really fast if you didn't get a decision you liked in whatever capacity it is, and find out what you need to file and do it timely. And then follow the proper procedures. And if you do your homework and do it right, then you should prevail. And I'm going to just add a little scripture in here, only because I think it's so important. The King James Version, and it's so hard to read the King James Version. I mean, when I was growing up, I didn't know what it was saying. I just never read it all.
Right.
But Romans 5:3, it says, and not only so, but we glory in tribulations also, knowing that tribulation worketh patience. And I'm going to put that in plain English. What that means is it's never easy to get the right judgment. But if you know you're right, you must fight on. And one of the English versions of the Bible, it's for that same provision. Listen to me, I'm talking like a lawyer. That same scripture is, we should rejoice in our suffering, knowing that suffering produces perseverance. And a little bit further down in Romans 15:4, goes toward that same thing. And we're the chosen ones if we have to persevere. Or it actually says, the scripture says, for whatever was written before was written for our instruction, just like our laws, so that through our endurance and through the encouragement of the scriptures, we may have hope. And basically that means that don't give up. You appeal if you're right.
Absolutely.
Have hope. Don't fear. Embrace it. Make lemons from lemonade.
Right.
Lemonade from lemons. I always get that backwards.
Right. Well, that's right. And the appellate courts, I just want to say this, that when you appeal and it goes up to the appellate court, how the appellate court is going to look at an appeal is they'll examine the proceedings. There has to be clear errors in the proceedings that have been preserved on the record, and I think you explained that to us.
I am so glad you brought that up. There's three things. I'm going to let you go on. Error, preservation, and I always have to read this, and it has to be reversible.
Yes.
Three things. I mean,
Right.
just remember those three things.
Mm-hmm.
Error, and you have to make sure there's error in the record.
Right, and it's got to be preserved in the record,
Yes.
and it has to be reversible. Example of
Yes.
something reversible, failure of a judge to allow the defendant to represent themselves, that's automatic reversal.
Yes.
Uh-huh.
Yes.
These
yes.
errors have to be, the errors have to have significantly impacted the outcome of the case.
Yes.
In other words, it can't be something that is, the person was guilty anyway, everybody knew it.
Yes, yes. The guy had the smoking gun in his hand, and he's already admitted to it. That's not
Right,
reversible.
that is not reversible,
But that does bring us the death sentence. They're automatically appealed.
Exactly. In Texas, there's an automatic
Even with that gun
appeal.
smoking.
That's right.
Jodi Arias comes to mind.
Yes.
Crazy woman, but she didn't get
Uh-huh.
the death sentence.
Right.
I don't
But
know. I mean, my
automatic-
opinion is always but anyway.
But then the U.S. So you can appeal all the way up to the state's highest court, and then from that court, appeals go to the U.S. Supreme Court. Now they only take a few of the cases. They're sent thousands of requests. But they only take 130 cases a year, something like that. Anyway, we're about to go to break. We just want to thank you for listening and tell you that if you have questions for us, you can email us your questions at questions@legalconnectionshow.com. We'll be right back after the break.
With some questions
That's
from
right.
our listeners, right?
That's right.
Lone Star Community Radio is looking for those who are interested in hosting their own talk show with monthly and weekly slots available on Conroe's FM 104.5 and 106.1 and on irlonestar.com. Start your own podcast, create your first YouTube channel, and be on TV. Contact Lone Star Community Radio online at irlonestar.com or call the station message line at 936-647-3776.
Hey, Montgomery County, it's me, C.C. Holmes. And I would personally like to take this time to invite you, that's right, you, to join me every Saturday and Sunday from 3 until 7 p.m. where I will bring you the very best of smooth jazz, classic jazz, and indeed, yes, the soulful sounds of the 60s, 70s, and 80s. So come along and get jazzy with me. That's right, jazzy. Right here, of course, on Conroe's 104.5 and 106.1 FM, or worldwide at irlonestar.com.
Welcome back to the Legal Connection Show with Toni and Cheryl. Today we're talking about appeals, and Toni, you're going to talk to us about some appeals that you've handled.
Yes, I am, and basically some pointers on if you take this on, if you are that brave and you have the right to do it, represent yourself, on how to handle an appeal. Just some little tips. I will say this: in addition to a lot of the appeals that I've done, I've learned so much with every appeal. It's amazing, and I've, without getting into the nitty gritty of those specific ones, I will say this: sometimes the trial court gets it right. Okay, as much as I appeal. The appellate level there's different levels. The trial court gets it right. Somebody's mad. They're unhappy with the result. They go to the appellate court, the next highest appellate level, which in Texas would go from district to, depending on whether it was civil or criminal, to the next highest level would be the Court of Appeals. And depending on what jurisdiction you're in Houston, you'd be in the 1st or the 14th. If you're in Montgomery County, you're going to be in the 9th. But sometimes those appellate courts are too filled. They have too much business, and it gets transferred to a different court. And that's happened to me on a number of my cases. They've gone to the 13th or the 1st or the 14th. Now, I'm just going to give you an example of one case where they got it right in the trial court. The Court of Appeals improperly reversed it, and the Supreme Court of Texas reversed it back again. Okay, so this appeals can go on forever. And if they wanted to, they could have gone to the United States Supreme Court next up. And if they were unhappy with this, for whatever reason, they could have even gone to the federal court for various reasons. I mean, it's not over until it's over.
Right.
You can just, if you should never give up. Perseverance is very, very important. On this particular case, on Dunn versus Dunn, it was a Supreme Court case in 1969, and it's still valid law. Basically, it had to do with oral renditions of judgments. You know, you'll go to court sometimes, and the judge will actually make a decision right there, but you don't have an order in writing. And in this particular case, it was a divorce, and Mr. Dunn died 2 days after the oral announcement of how the divorce was going to be split, how the property was going to be split in the divorce. And the wife was like giddy about it, and so she went back in and she said, I'm going to move for dismissal. We don't have a final judgment. There's nothing in writing, and that's the only thing you can appeal on. And the appellate court said, oh, we agree. Okay, so this is going to go, his estate will go intestate. The divorce is gone. We dismissed it. There was no divorce. Well, when it went to the Supreme Court said no. An oral rendition has the same weight as an actual order.
Really?
If it is not in writing, and they actually made a law out of that in Texas, and it's Texas Rules of Civil Procedure 306A. But if you have an oral rendition, you don't have to wait for that written order for it to be, if you get a transcript of it and can show somebody, like with my temporary orders all the time, it's valid law. And a lot of policemen don't know that. They look for the actual order when the police are over at your house and what have you.
Right.
But it is valid law versus done be done, all right? And then before I turn this over to you, I'm just going to say a couple of things about the people that want to handle appeals on their own. It is very, very difficult. If you don't get the procedures right, if you don't get the font right, if you don't get everything right, it will get kicked out and you will lose. And I'm not trying to promote this for attorneys that are trying to make money, because I do many of my appeals for free, and I'm not advertising to do anybody's appeal for free.
Right.
I will not do it. I will pray and beg the Lord not to make me do another appeal, because they are that strenuous on me as well as my clients. But if you are going to do it on your own, it usually goes to an appellate panel, which is, there's 3 appellate attorneys.
Good.
You can ask for en banc, I think it's what it's called, for all of them to look at it if you don't get a decision that you want from them, or go up to the higher level. There's lots of different options. And another example is in bankruptcy. You don't appeal to an appellate court. You appeal to the district court in federal bankruptcy. A lot of different things going on. So there's lots. Just read the rules. Here, though, if you're going to appeal, limit the number of issues being raised in your appellate brief. Appellate judges loathe briefs that appear to be throwing things at them like everything in the sink.
Right.
Keep in mind that an appellate judge has a heavy reading load. As such, to avoid potentially frustrating the judge, keep your brief focused and concise, unlike our show today. Or what we're trying. And study opinions in the cases analogous to yours to
That's
determine
so important.
what underlying facts and what legal authority were necessary to write those opinions. We learned that at South Texas. I won a number of competitions at South Texas writing this for brief writing alone. You've got to find the law and see, just like Roe v. Wade, you're trying to find, and nothing's been overturned on that yet, because that's the supreme law of the land, unless it gets overturned for something else,
That's the case that made abortion legal.
Yeah,
Roe
which
v. Wade.
started out as a district court case, and it ended up in the United States Supreme Court because it was it had a federal question. It was a question of whether the Constitution
Provided the right.
had provided that right. Okay. That being said, I'm giving you 3 examples of, and this goes on and on, but we want to get to our listener questions. That's what this show is about.
We do. We want to get to our listener questions, but I just want to bring up one thing: is that there's a limited right to appeal when you plead guilty. You have the right to appeal, but it's limited. And I think that's kind of frustrating. You can't go back if you were, people plead guilty to things for
And they were
tons of reasons
coerced.
that don't have anything to do with their guilt.
Right. Because the prosecutor tells them, and they can do this.
I know.
Oh, if you just say you're guilty, you're going to get off, you'll go home today.
That's right.
Do you know how many of
This will
my
all go
clients
away.
are like 17, 18, 19 years old without their parents there because they're deemed to be an adult, and they want to get out of jail?
Right.
And
They want to go home.
They want to go home, and they're so immature that they don't realize that that's not the right thing. Just say whatever they want. You have to
Absolutely.
tell the truth.
Absolutely. Important. Okay, here's a question.
Or let me do one caveat, though, being a criminal defense attorney. Remember your Fifth Amendment right, because whatever you say can and will be held against you. So get your lawyer and say nothing.
Absolutely.
But if you are going to talk, tell the truth. Okay? I say nothing as a criminal
I do
defense
too.
attorney.
I think say nothing.
Okay.
Truthfully, remain silent.
Yes.
Okay. When may a litigant file an interlocutory appeal? I think interlocutory appeal is important because what it is when something is going on in the trial court that you think is wrong, rather than finishing to the end of the trial, which is time-consuming, expensive, taxpayer dollar, personal funds, all of that. You can, at times, in limited circumstances, make an appeal instantly to a higher court. So we have one question here that a litigant...
This is one of our listener questions, right? Okay.
A litigant, the person who brought the lawsuit, when can they file an appeal to a higher court immediately and not have to wait until the final disposition of the trial case? An interlocutory order is a trial court order that does not dispose of all parties and all claims in the case. An appeal of an interlocutory order is an interlocutory appeal. An interlocutory appeal is only possible when expressly allowed by statute.
Yes, and there's a list in the statute.
Texas Civil Practice and Remedies Code, sections 51.014A lists a number of interlocutory orders which are appealable. And I just want our listeners to know that there are times when something goes awry in the trial court and instantly you can get an appeal. Most often, you have to wait until the final disposition of that trial to appeal to a higher.
And if it's one of the claims within the case, because a lot of times there's more than one claim. In civil cases, a criminal's a little bit different. They can actually ask that claim be severed so they can get a final judgment to be able to appeal
that
it.
one.
Or they can mandamus, which is a whole different type of appeal, but that's your other option when you have something that's going on during court where you don't believe you had the correct decision made by the judge.
Okay. And then just one more really quick. In order to appeal, a lot of times the litigant has to file a bond, a cash bond, and another thing that's expensive. And all of these expenses really bother me. But the bond or cash deposit must be in an amount equal or greater than the sum of the compensatory damages awarded in the judgment. Sometimes we're talking about huge figures.
And that also is statutory. The judge has to approve it. And I've gotten those before, and you're locking up a lot of money in a supersedious bond.
You sure are.
You got to really think twice about appealing a lot of these civil cases. It's not a happy thing.
No, it's not.
But I've done that before, and I've locked money up, my clients' money up before, and we've won, and it's well worth it when you win.
Well, good for you.
So it doesn't mean I'm great. It means the facts in that particular case supported that there was going to be a victory.
All right. Well, we want to thank you for listening to this afternoon's The Legal Connection Show with Toni and Cheryl. We're here. We just want to serve you and take your questions, listen to you. And we'll see you next week. Hear you next week.
Serve God by serving each other.
That's
We're doing
right.
a public service for you, and we expect you to do the same for other people.
Next week, irlonestar.com, 104.5 and 106.1. We'll see you then.
Thank you for checking out this production of Lone Star Community Radio. Lone Star Community Radio is Montgomery County's community radio station. Don't forget to check out this show and many others across the Lone Star Community Radio Network, either live on Conroe's FM 104.5, 106.1, the Lone Star Internet Radio app, or irlonestar.com's live audio stream, and on replay on podcast, Channel 12's Our City TV in Conroe, or Channel 21 KVQT in Houston, and of course their YouTube channel. This production is copyrighted and all rights are reserved by Lone Star Community Radio. Have a question regarding this program or other Lone Star Community Radio shows? Want to sponsor or start your own show? Call the station message line at 936-647-3776 or email the station at lscrstudios@gmail.com.